Justice, may it please the court. My name is Scott Wilkinson, and I represent the appellant mutual funds in this case, Wells Fargo, Pioneer, and Lord Abbott. It's my intention today to reserve about 4 minutes of my time for rebuttal, and I'm willing to waive free fire.
Okay, that's fine.
I'll get right to the quick of the issue. We're here and we're requesting that the court either peremptorily reverse the Court of Appeals decision or grant leave to appeal for 4 reasons. Number one, the Court of Appeals decision incorrectly found that the consent judgment in the underlying case is a determination of the conduct of EMC's insureds Helicon and Watucky. Number two, if it was a determination of their conduct, it is not a determination that their conduct rose to the level of fraudulent or dishonest conduct. Number three, the Court of Appeals decision disregards several well-established policy construction principles that the court was required to adhere to. And finally, number four, if left in place as written, this decision has a chilling effect on the insurance policies bought by thousands of Michigan insureds. I'll get right to the issues that the court asked for additional briefing on. Number one, is the consent judgment from the underlying case a determination of the insured's conduct? The answer is no, and it's been addressed by both this court and the Court of Appeals. Back in 1975, the Court of Appeals in American Mutual v. Michigan Mutual looked at the issue of whether a consent judgment was sufficient to support application of collateral estoppel. The court in that case said no, it was not sufficient because the court in those cases does not consider or adjudicate the issues as between the parties. The appellate court at that level said that the consent judgment is basically just a settlement that has been blessed by the ministerial action of the court. This court later in 2014 in the Acorn decision reached a similar conclusion, albeit under a different factual predicate. In Acorn, this court said that a court does not determine the rights and obligations of the parties in a consent judgment. Applying Acorn and American Mutual in this case to a consent judgment is dispositive of the outcome. The Court of Appeals should not have applied the fraud exclusion requiring a reversal. Now, because those cases are dispositive, EMC tries to get around them by saying, well, this isn't a consent judgment. Okay? And that's simply not the case. We can look to that for two bases. Number one, if we look at the docket at the trial court level, the court apparently believed it was a consent judgment because it entered it as such in its docket. But more fundamentally, as a common sense perspective, there's nothing else that this judgment could be. As a litigator, I'm familiar with only 3 broad categories of judgments. The first is a default judgment. That occurs when somebody doesn't show up to defend. Clearly not the case here. The second is a litigated or adjudicated judgment. That is the result of a trial court or a jury resolving an issue for the parties. We see that in an order granting summary judgment. We say that in findings of fact and conclusions of law issued after a trial to the bench. We see that in a form of a jury verdict form. None of those are present here. The most that EMC can show from the trial court in this case are orders denying summary judgment. What that says is, parties, you've established enough facts to proceed to trial. It does not say one party is right and one party is wrong. What's left? The only thing that's left is a category of consent judgments, agreed upon judgments, stipulated judgments. Those judgments can only be entered if the parties agree to their entry. And that's what we have here. A judgment that was agreed to, was entered without any determinative effect by the court, and cannot be given credit as a determination in accordance with Acorn and American Mutual.
Well, in approving such a consent judgment, the court is not just a bystander. The court is presumably exercising in some way the judicial power of the state. I mean, what are the standards? What precisely is a court saying when it approves a consent judgment?
Well, if we look to Acorn and we look to American Mutual, Your Honor, the court is saying that it is ministerially approving the party settlement. That is it. Nothing more. Having said that, the court also asked the question, if this is a determination, if the court is to treat the consent judgment as a determination of the insured's conduct, is it a determination that they engage in acts of fraud or dishonesty? And the answer there is likewise no.
There's no greater dignity to a consent judgment by virtue of the judicial involvement in the process than there would be in any other settlement. Is that right?
Your Honor, I believe the only difference that would be accorded to a consent judgment is that it is enforceable as between the parties as a judgment.
Is there some sense in which the court assessing the consent judgment is saying that what's being agreed to is not imposing a fraud upon the court, it's not incompatible with reality in any respect, it is a valid thing for parties to be doing, it accords with the truth in some fundamental respect?
Your Honor,
in some minimum way, it may satisfy the relevant statute. We don't know exactly how, but in some minimum respect, it arguably does that.
Your Honor, I would respond to that in two ways. If we look to the guiding case law being Acorn and American Mutual, they speak to no such threshold determination by the court. The second way I would address your question, Your Honor, is that...
Was any such threshold made here by the district judge?
Your Honor, the only thing we have is the content of the consent judgment itself. It was submitted to the court by the parties, and it was signed by the judge with no changes.
Can I ask a question? I'm sorry. It just dawned on me. Why are we using state law to evaluate the effect of a federal judgment? Like, this is the judgment from the Eastern District of Michigan, right?
Mm-hmm.
So why does state law construe what the federal judgment means? Shouldn't federal law construe what
Your Honor,
the federal judgment means?
It's a very good question, and I think...
would my answer be different? I guess is really what I care about.
Yes, I think, Your Honor, the answer becomes because this is a state law proceeding brought in state court about the effect of that judgment on an insurance policy.
Yeah, but what that federal judgment is not governed by what we think it is, but federal law, right?
Your Honor, I could see that argument, and what I would...
You can see it.
Yes, and where I'm going with this, Your Honor,
I mean, because the reverse, right? If we entered a judgment, we would expect the federal court to follow what we thought it meant, not what they think it means, right?
Yes, Your Honor. Yes. Your
That's
Honor.
what happens in a federalism system. We apply each other's law.
Mm-hmm.
Right?
Yes, Your Honor.
So what's the best argument under federal law that the federal courts do not consider a consent judgment an adjudication or determination of the merits?
Your Honor, the best thing we could do is go to some of the other cases examining these issues under federal law, and one of those cases...
What's your best one?
Washtunik. Washtunik is the best case that looks at that. In that case, there were Federal Securities Act claims, and in that case, the court reached a similar conclusion. A consent judgment is not a determination that is sufficient to trigger a fraud exclusion in the policy.
Counsel, is it your view that it can never be the case that any consent judgment can include or be based on a determination, or just that in this case it was not? I'm just, for example, if the parties had agreed to and put in writing in the consent judgment that this is to be a determination that your client did X, Y, and Z, would that count as a determination?
Yes.
Okay, so it's
Yes.
your position is not that across the board, no consent judgment can ever be a determination. It's in this case, it is not.
That's correct. If we look at and again, you know, we're citing to Michigan law, but we're not aware of any difference between Michigan and federal law.
Well, at least in the United States, the International Building Company had a Supreme Court case. It said, I should say, a judgment entered with the consent of the parties may involve a determination of questions of law and fact by the court.
And Your Honor, I think that, and again, I don't have that in front of me, but I think that line of cases is indicative of the answer I just provided, which is if the parties are putting in the judgment determinations of fact and determinations of law, the action of the court in signing that agreement of the parties does in fact determine that.
And so the way we know that this is one that didn't do that is because there are no findings, fact, and conclusions of law in the judgment.
Thank you, Your Honor. And that actually gets to the second point I was getting into, the question of whether this rises to a level of fraud or dishonest conduct. If we look at all of the cases that have been cited in this case, and it's Washtunik, it's Central Power, it's Jensen, it's Clarendon, it's Illinois Union, that interpret fraud exclusions in the presence of these policies, They all have required that a judgment be entered that has a claim that has some element of intent or some element of scienter. The reason for that is fairly obvious. We're dealing with a set of policies here that expressly grant coverage to misstatements and misleading statements, but exclude coverage for fraud or intentional conduct. To have that fraud exclusion not swallow that coverage grant, we have to distinguish in some fashion between negligent conduct and intentional conduct. That's why we require those elements of intent. If we look at the consent judgment in this case, if the court were to treat it as a determination, the best that can be said for it is a determination that Helicon and Witucky violated the Connecticut Securities Act. The Connecticut Securities Act is a negligence-based statute. It does not require a finding of fraud or intent. That means in this case that at best, the consent judgment establishes that Helicon and Witucky acted negligently. It does not establish, if it establishes anything, that their conduct rises to the level of fraud or dishonesty. Which brings us back to the bigger picture. The underlying fundamental problem with the Court of Appeals order is that it doesn't adhere to the fundamental policy construction principle that we have to give effect to all words and phrases in the policy. The Court of Appeals adopted a definition of dishonesty that is so broad, it takes out of coverage the express coverage grant for misstatements and misleading statements, both of which, by their definition, are untrue. So when the Court of Appeals said dishonesty equals untrue statement, it said, oh, by the way, this coverage grant over here might as well not exist. We can't do that. That's going to adversely affect everyone with this kind of policy.
Why can't the consent judgment reasonably be understood to establish or signify that Helicon did the least amount of misconduct necessary to violate the Connecticut Uniform Securities Act, which was at issue? The least amount of such conduct, as I understand it, under that statute, which includes both intentional and negligent misconduct, would, of course, be the negligent misconduct. And, of course, breaching the prescription against negligent misconduct would not implicate the policy under your interpretation of the policy. So you'd prevail under that alternative theory as well, wouldn't you?
Yes, we would, Your Honor.
Why is that not the better way of doing things?
Your Honor, that's why we've asserted them as alternative arguments. We're taking the position that it is not a determination, but if the court finds that it is, Your Honor, we would agree with you that it rises to a level no higher than that.
But it isn't even, there is no acknowledgement of responsibility in the consent judgment, is there?
There's not, which is why we've also argued it's not a determination of anything. It is merely a finding that they owe $4.whatever million.
So the judge is to bring no judgment whatsoever to bear in his or her assessment of a consent judgment. It is purely ministerial, as you say.
That's our belief, yes, Your Honor.
Okay.
All right. I see that my time is up. You know,
You
at this point,
2 minutes.
Pardon me?
You want to reserve your 2 minutes or talk?
I'm going to present the conclusion here.
Go ahead.
We believe that there's basically three options the court has at this point. One is to deny our application. We believe that would be hugely devastating, not just to our clients, but to all Michigan insureds whose policies are going to be affected by this decision. They're going to be deprived, or the insurance companies are going to have a basis for trying to deprive their negligent misstatement and misleading statement coverage. We believe the appropriate resolution here is to remand, peremptorily reverse and remand, so that the Court of Appeals can address the remaining exclusions on appeal. That said, EMC has invited this court to address those exclusions, but we have not had the opportunity to brief them. So if the court is inclined to get into other exclusions beside the fraud exclusion, we would ask that the court grant us leave to appeal and allow us to address those. Thank you.
You know, just one further question. I mean, even from your point of view, looking at the alternative approaches, which either involve giving dominant consideration to the consent judgment or trying to understand what the minimal interpretation that could be derived from the consent judgment was, if we were to do the latter, which you say is your alternative approach, you would at least have to necessarily engage in some interpretation of the policy to assess to what extent it encompasses negligent and intentional misconduct. If the case is resolved on the basis of the consent judgment, you simply avoid that question altogether, don't you?
As I understand your question, you're asking, do we need to engage in policy construction?
Well, if you want an answer concerning how we give meaning to the kind of insurance policy that's at issue in this case, in which you think that the lower courts have, consumed the exception or consumed the general rule within the exception, wouldn't the answer to that be, well, let's take a look at the statute, which is at least something that you have to do if you look at this from something other than the perspective of the consent judgment?
Yes, I think the court could take a
You
look
get an
at...
answer to the question that you apparently think is important. You apparently get an answer to what you view as the dominant question, how we reconcile the general rule in the policy with the exceptions set forth in the policy. You don't get that answer if it's resolved on the basis of the consent judgment.
I think I now see where Your Honor is going. You're saying if the court were to determine that this is not a determination, we don't get a resolution of the later issue as to whether dishonesty encompasses any untrue statement. Whereas if the court were to resolve this issue on the basis that it is a determination, but it's only a determination of the minimum level of conduct, then in that case, we get a resolution of the dishonesty issue.
Couldn't that be accomplished? Can it be accomplished if we determine that the Court of Appeals determination about the construction of the exception is incorrect? Can't we simply vacate it?
Yes, Your Honor, you could simply vacate it and send it back down.
Let that determination be worked out at the trial court?
Well, I think Your Honor, I think the first step would be if you peremptorily reversed and remanded, then it would be for the Court of Appeals to address the remaining exclusions that are pending on appeal.
Well, but that would leave, unless we specifically address their construction, that would leave intact their determination of what that exclusion meant.
Your Honor, for both my client's sake and for the sake of other insurers in the state of Michigan, I think there has to be a reversal of the opinion and a remand back down. I think that... Well,
we could reverse on the basis that the consent judgment was not a determination.
But he's urging us to do more than that.
Yeah,
I understand.
Yeah, I think in order to protect, this court urged when we first got here today to think about not just your case, but cases to come down the road. And there are two things that scare me about this case. One is the definition of dishonesty that is so broad it swallows the exclusion. The other is the fact that if this was to be treated as a determination to trigger this policy, we're calling into question whether consent judgments in other areas are treated as determinations for other aspects, collateral estoppel, whether we get into these other issues. And I think that's disconcerting as well. I think we need to balance the apple cart there. Thank you.
Thank you.
May it please the Court, Your Honor. Megan Cavanaugh appearing on behalf of Employers Mutual. I will waive my free fire.
Did you misspeak in your brief? I believe you said in your brief that this was not a consent judgment.
I don't believe it is.
You did in the Court of Appeals, and Judge Murphy did.
Judge Murphy. Oh, in the federal court.
Yeah.
I don't.
That's what he put in his order.
I'm sorry?
That's what he said in his order, isn't it? Right?
I don't.
The parties eventually entered into a consent judgment April 25th, 2012, resolving the disputes. Is an order adopting the report and recommendation and granting in part motions for attorney's fees and costs. Did he not know what he was talking about?
I'm sure he did. I'm sure he did.
Am I not supposed to then treat this,
well,
what he approved, as a consent judgment?
Well, and what I have said is that I think absolutely when you look at the order that was entered in this case, not the class of consent orders in general and how those can be structured or worded, they consented to the entry of this judgment.
Yes.
As to form,
Yes.
without an admission or denial of liability, without the standard statement of, plaintiffs bring these claims, defendant does not admit liability. In fact, in looking at this, Helicon or Watuki would have been able to file a notice of appeal from this judgment to the Sixth Circuit to challenge Judge Murphy's determination on the legal conclusions on the denial of motion for summary judgment. And quite frankly, it's done all the time, where you're not going to get a better record at trial. You have lost the war, you know, hands down. You are against the wall, but your best facts on the summary judgment are not going to get any better at trial. We're going to enter into a judgment to have an appellate court look at that law, at that legal determination.
They just want to cut their losses.
I'm sorry?
That's what happens all the time. You cut your losses. There's no admission of liability, but you say, I don't want to spend any more money on lawyers, so I'm getting the heck out of this lawsuit.
Correct.
Okay? I don't understand why that renders this consent judgment a determination of anything other than, I don't want to continue this.
Well,
It was approved as to form, not as to substance.
correct.
Even if there was a substance, I don't know that there's any substance in it.
Well, I think that there is, and I would be in a much more difficult situation if this order were labeled consent judgment, defendant doesn't admit anything, but we agree to pay the plaintiff's X. I would be in a...
If it's agnostic on who's at fault, does that create an inference that I am admitting fault? If it's approved as to form only, does that create an inference that I'm accepting liability?
If it's agnostic as to fault...
Unstated.
To anyone.
It says nothing about acceptance of responsibility. It's a consent judgment. I agree to pay X. Adios. Approved as to form.
Mm-hmm.
Why does the ambiguity mean tie goes to your client as opposed to the other side? You each could have slightly better facts, right? You could have a consent judgment that's spelled out that this is a determination that, you know, these 5 things went wrong. You don't have that.
Mm-hmm.
He could have better facts because he could have said this judgment is not, you know, not determinative of any
Right.
wrongdoing.
Right.
We have neither. Why does neither?
Well, because I think that the specificity of this order that was entered and the specific reference to Section 36B 29 sub A2,
Right.
and remember that this was entered where plaintiffs had at the time, after having eliminated all the intentional securities fraud claims out, claim under the Michigan, the Massachusetts, and the Connecticut statute, and I believe a negligent misrepresentation claim still pending at the time.
Couldn't there be a settlement that just says defendant or defendants agree to pay X number of dollars in exchange for dismissal of all claims, undifferentiated?
There could be, and I would have a much harder argument.
No, I understand.
On that.
So the situation we have is that defendants agreed to pay the various plaintiffs on one specific claim, which is identified in each of the paragraphs of the judgment, and then the judgment goes on to say that all other claims are dismissed. So there really can be no doubt that the plaintiffs were being paid as it relates to this one specific claim.
I believe that that's true. I believe the specificity of this order that is what makes this a determination of the insurer's conduct. That's the answer to the first question.
Okay, can we move on to the second one?
Yes.
Do you concede that your policy's fraud and dishonesty exclusion does not include coverage for acts or statements or omissions that are merely negligent?
Could you repeat that again?
Yeah. Do you agree or do you concede that your policy's fraud and dishonesty exclusion does not exclude negligent misrepresentations, negligent statements, negligent acts or omissions?
I want to answer the question directly. I don't believe that the exclusion, or I do believe that the exclusion applies to the, at best, if you characterize the Connecticut statute, Helicon and Watuki's negligence. If you construe it, but I take issue with calling it negligence, and here's why.
But that's a different, that's
Okay.
a different question. So your answer to my question is, yes, I concede that our policy does not exclude the negligent misrepresentations. Negligence is covered in your policy.
Negligence is covered in certain circumstances with respect to misstatements.
Okay.
And
you also concede that the Connecticut statute, the one at issue here, an individual can be held liable for misrepresentations or omissions that are merely negligent.
With the understanding, the common parlance of negligence being knew or should have known, and should have known.
So kind of yes.
Oh, no, negligence is just, you didn't do it. You were just careless.
You were careless. And here's where I would like to go in answer to this, and in looking at misrepresentation. There is intentional misrepresentation, fraudulent misrepresentation, negligent misrepresentation, which you don't need to prove that the insured knew what it was saying was. It was that they failed to exercise reasonable care. They should have known.
Right.
The second step of that. There is an innocent misrepresentation claim for which a insured can be subject to liability to the plaintiffs in this case. For example, despite not knowing, I did not know that this statement I made, whatever it may be, that Bay Mills needs to authorize this.
It was still untrue.
It was still untrue. And despite all the knowledge available to me and me doing my due diligence, it turns out it was still wrong at the time to their detriment.
Is innocent misrepresentation included within the coverage of your policy?
I believe it is. Because innocent misrepresentation would constitute neither fraud nor dishonesty. And we have, again, speaking in generalities, we're talking about this judgment, which directs us to conduct under a specific statute. And we are talking not about the broad meaning of judgments, the preclusive effect of judgments in general in the body of law. We're talking about the meaning of terms used in an insurance policy. So do you have a judgment that determines that the insured acts or committed acts of fraud and dishonesty?
I just want to make sure I understand. Innocent misrepresentation is a representation made without intent, without knowledge, that turns out to be untrue.
To the other person's detriment. Correct.
That is encompassed within well, first, that is a violation of the Connecticut statute.
No.
No?
it's not.
Okay.
That's the
Oh,
No,
gotcha.
it's not.
All right.
It's not.
And that's the distance that I'm interested in. It sounds like you agree that there is some difference between a statement that's untrue and a statement that's dishonest.
Yes. Yes, and I think that
Because my son, he really thinks he's an awesome basketball player. He'll tell you it. He'll tell you that he's a fantastic, and I am here to tell you he is not.
he's not. Well,
He is a terrible basketball player.
He must love
But
hearing
he
this.
honestly believes he is a really good basketball player.
if for example, and to use, as an example of some of the, what's interesting is that if you look at the summary judgment, the pleadings and the order that was entered in the other case, the only thing that was contested and subject of the summary judgment motion was whether or not Helicon qualified as an offerer or seller or materially assisted in the offer or sale. There was no question that these statements were either known or should have been known to be false. There was no question that the other elements of the statute, that the buyer didn't know of the untruth or the omission.
But there may well be a lot of other ways your client should win this case.
Correct.
But
Correct.
we're concerned with a published Court of Appeals opinion.
I agree.
That sweeps an awful lot of conduct.
I agree, and that's why which is why at the court's request to pull apart this order that we're talking about, pull apart the words, pull apart the language used in the insurance policy, this case, and I know that this is usually a very unpopular answer when I'm up in front of you saying, you know, in my case, because you don't really care about my case, which is why I don't think you should grant leave
You've
in
heard
this
us
case,
say
right?
this a million times.
Is that
You've been here before, haven't you?
is that this order and this policy and this particular Connecticut statute, when you look at what that is, if it is not the broad range of consent judgments that now, in the grand scheme of all policies, fraud and dishonesty exclusion, I understand the concern with the Court of Appeals opinion that could perhaps be interpreted that way.
And it's published.
And it is
And
published.
if it wasn't published, maybe that would be a good answer.
Well, but I think that there are alternatives, that there's relief that this court can afford that affirms this decision, in this case,
On other
this
grounds.
order, on other grounds, or on this order, this policy, in light of the Connecticut statute, that affirms
see.
this,
We
that
could-
this policy exclusion does in fact apply to bar coverage for the funds claims.
So we could write a much narrower, less sweeping, less
Whether it be
worrisome-
vacating the Court of Appeals opinion, right result, wrong reason, not, or, yeah, I think so. And as you know, the trial court addressed all exclusions that were raised. The Court of Appeals chose to only address one, and obviously we have said, and to be honest, the other two exclusions do not have the judgment determination requirement. And in that circumstance, we are not bound by what judgment or what claim that they decided to proceed under or seek a judgment under as the insurer. If I was shot and I secured a judgment that said that somebody was negligent towards me, my insurer is not bound by the finding of negligence. They're bound by the finding of a judgment. But the insurer can go behind that judgment and prove that the insured's conduct, which is what determines coverage, was nevertheless excluded under the policy, which is I think what we have done with this exclusion, but in addition to the others. And that whether it be affirming the Court of Appeals opinion or affirming judgment in favor of Helicon by either vacating or narrowing the Court of Appeals opinion, or I suppose it's absolute alternative is to remand it to the Court of Appeals to consider
The remaining claims.
this with the others, or to consider the other two.
Ms. Kavanaugh, I think the more precise statement is that we are not exclusively concerned with your case, as opposed to not being concerned with your case.
I did not mean to suggest otherwise, yes, yes.
Thank you very much. Appreciate
Thank you.
it. Prior, do we have any time left for the appellant? No. Okay, well, thank you very much.
Thanks anyway.
Yes, I'm sorry. We need to try to accommodate the parties in our next case, and we're going to come back just a little bit earlier than ideally I'd like to, at 1 o'clock. Thank you.